I'm very pleased to introduce our next panel. And our panelists include Stephen Cavanagh, a defense lawyer who leads an 8-lawyer firm in Ottawa, which focuses on professional liability, commercial litigation, and insurance law. On 3 separate occasions, Best Lawyers of Canada has announced Steve as the Lawyer of the Year in the area of insurance law in the Ottawa area. Since 2007, Stephen has been a member of the Ontario Civil Rules Committee, so he's been on that committee for quite some time, and he'll be talking about some of the work that he's done on that committee. Our next panelist is Joseph Obagi. Joseph practices with Connolly Obagi, an Ottawa personal injury firm. Joseph is also recognized by Best Lawyers in Canada and is a certified litigation specialist. Joseph has had a very impressive number of jury and judge alone trials over the past decade. Many of his court decisions are leading cases in those areas of law. The topic that Joseph and Stephen are going to be debating is going to court versus litigating from your basement. I'm not going to tell you who's going to be advocating with which position, but you'll figure that out very quickly for yourselves. Both Stephen and Joseph sit on a bench and bar committee where they are debating and discussing these issues. And Stephen, I'm going to start out with you. Maybe you can tell the audience about the Civil Justice Working Group, about changes that have already been recommended and implemented, and what further changes you see coming down the pipeline, and whether these changes are necessary in your opinion. So Stephen, I'll put it over to you.
Thanks, Gary. When I agreed to do this, I hadn't seen the title Going to Court versus Litigating from Your Basement, and I suspect that I'm being cast in the role of the basement litigator, which is completely false, even though all of my litigation on Zoom is fake. My background, everything about it usually is fake. It's all been on the ground floor. So, but I do keep reading that sleepy Joe Biden can't find his way out of his basement, so maybe I'm in good company. So Joseph Obagi and I were, I think, asked to speak because we're both on the Civil Working Group, which is an ad hoc committee that's been struck recently since the pandemic started. It's co-chaired by Regional Senior Justices Firestone and McLeod. There are a number of judicial representatives on it and representatives of many, probably most of the various bar organizations, such as OTLA and the OBA, the Advocate Society, and so forth. And it has so far worked mostly on proposing some changes to the rules of civil procedure, and has gone through some changes, what probably might be viewed as low-hanging fruit, because they are changes that were obviously being made necessary by the change to a largely virtual litigation environment. So we've done things like remove references to telegrams from the rules, and faxes are on their way out too. Things like filing electronic versions of transcripts hadn't already been provided for in the rules. So there are many changes that reflect, many changes that the Civil Working Group agreed upon that reflect the new reality of virtual litigation, which is probably going to continue, well, to some extent forever. The Chief Justice has said we're never going back to a paper-based environment. So the changes that have been agreed upon by the various members of the Civil Working Group have been passed on to the Civil Rules Committee, which I'm also a member of, and they have the Civil Rules Committee has largely, I think, accepted the recommendations, or has accepted the recommendations of the Civil Working Group. So I expect that those changes are going to be passed this year, but they're probably not the end of the changes that we'll see to the rules. Some of the changes that were discussed were considered to be a bit too much of a leap so far. For example, one thing that probably led to my being on this panel was I had been pushing for something that had been suggested by Justice Robert Baudouin, among others, and that is making applications the default way of initiating a civil proceeding. That hasn't been done, and it may yet be done, but that would be a much bigger change than the sort of thing that has been done so far. Justice Fred Myers, who is also on the Civil Working Group, he and I prepared a kind of a laundry list of changes that could be considered, and many of those were felt to be a step too far at this point, but that doesn't necessarily mean that they won't be considered in the future. So as I said, those changes are largely reflective of things that are already taking place. So for example, Rule 1.08 that deals with the use of this sort of thing, video conferences or telephone conferences to conduct various steps in litigation, that's been fine-tuned a little bit to reflect what people were already doing mediations on Zoom, doing pretrial conferences, discoveries, and so forth on Zoom. So I don't think anyone is going to find those terribly controversial, but I think there is probably quite a ways to go in terms of actually not just adjusting to what we're already doing, but rejigging the way civil litigation is conducted in the province. So one of the things that I had advocated, again unsuccessfully, I'm not sure why I'm still on this committee. I don't seem to have much of a winning track record, but I'd advocated more use of written advocacy, and in fact put that into practice on a motion before one of our local judges to strike a quite complicated pleading in a large multi-million-dollar commercial lawsuit. And this has been going on for a long time. There are many parties, and Justice Gomery, who's hearing the motion, who's also on the Civil Working Group, she suggested that we do the motion in writing, and everyone, a bit surprisingly, everyone agreed to it. So that is still under reserve with Her Honor. I think Joseph, and he'll speak to this, I think he certainly sees dangers in departing too far from oral advocacy, in-person advocacy, but certainly face-to-face, either on a screen or in real life with the judge. So we may differ a bit on that. But so far, he's had his way before the Civil Working Group. Just to touch on some things that I know Gary wanted to talk about, and that is, where are we going in the future? And something I think it's important to remember is how little time has gone by. Only 7 months have gone by, and we've had what I think are the biggest transformations that there have ever been in the civil justice system in Ontario. There are things that many, including me, think should have been done decades ago. So litigants should not have to pay for lawyers to travel for hours to attend a 15 minute or half hour conference of some sort or brief motion. And I don't think we're going to see that again. We're going to see a lot less being done that is not a productive part of the process. So in the past, litigating in another city has been a big problem. It means travel. It means a local system that is perhaps has its own peculiarities. I think we're going to see a lot less of that. We're going to see a much more streamlined version. I predict we're never going to see another courthouse built in Ontario on the same template as has been used in the past. It's not courthouses built in the future are not going to look like what we have now. I already said the Chief Justice has said we're not going back to paper. But a couple of other things that I think we're going to see in the future. One of the things Gary asked us to reflect on is what is litigation going to look like in 2030? And two things that I think are going to be, people will be surprised to see. One is that I think this sort of thing, what we're doing right now, Zoom advocacy, there are many flaws that people have pointed out with this. You can't really make eye contact with someone else, whether it's a judge or a witness. I think within the next couple of years, we're going to see an environment where people, instead of doing this, they'll be wearing some sort of apparatus that will allow them to use extended reality, virtual reality, augmented reality, that type of thing, where it will be possible to simulate the environment of a real courtroom. And the other thing that I think we're going to start seeing, and we're already seeing, is having computers not just help the lawyers, but actually decide the cases. And the country of Estonia is already developing a computer system that is actually going to serve as the judge in small cases, I think about $8,000. And they're hoping that having the computer decide those cases is going to cut down on the backlog. So just to wrap up my section, the one thing that I think has been the biggest transformation and that will continue to be the biggest part of this new world of civil litigation is the way that we handle documents. And my own personal experience and what I've heard from other people who have done it is that handling documents actually works, if you are managing them correctly, it works more smoothly when it's done virtually, whether it's by sharing a screen or whatever, than it did in real life in the old days where you had to get the judge to pull one book out of a stack of 20, try to find the right book and then the right tab and then the right page of the tab. So I think that aspect of what we're doing now is probably going to continue forever. The other changes, we'll just have to see. Thanks, Gary.
Joseph, I want to bring you in on this discussion, and perhaps you can respond to some of the points that Stephen made in his discussion, and perhaps you can discuss some of your concerns with what he indicated was required to modernize our civil justice system.
Thanks, Gary. Well, definitely Stephen and I see things very differently as to where the future is. I certainly didn't anticipate we'd be wearing goggles to see virtual realities in the courtroom. That may be the case. However, I can tell you that the direction that Stephen was taking, and Justice Myers as well in the report, which, as he's indicated, was sort of a laundry list of issues that we were to talk about. So it was really a starting point. I don't think either of them intended it to be sort of the ending point. It may have taken on a little bit of a life of its own just because of the manner in which it was presented to the Civil Working Group. You should know that, as Steve pointed out, there were a number of bar organizations that are part of the Civil Working Group in addition to the judiciary that he's mentioned. OTLA, the Advocate Society, OBA, FOLA. Pretty much all of the bar organizations were heavily opposed to any sort of change that would see a defaulting of our justice system towards written advocacy or towards applications as opposed to actions. But let me take a step back, because my view of this is that the starting point in any discussion is that oral advocacy is a bedrock of our system of justice. Now, there's no doubt we're currently in a pandemic. And of course, because of the pandemic, there are certain things that require change in order to ensure the health and safety of everyone. But the pandemic itself should not change our fundamental values of justice. You may have seen me at a number of CLEs. I think, Gary, you introduced me as having done a number of trials. I have been on the CLE circuit for sure, and in the courtroom, a very strong supporter of the use of technology in our courtrooms. Our firm was one of the first to run a fully electronic civil jury trial. We equipped the courtroom, we equipped the court staff, we equipped the judge, and we even equipped opposing counsel sometimes with the equipment required to run an electronic trial entirely on iPads. And so from that perspective, Steve and I are both early adopters of technology in the courtroom. So you would expect our views to be more in line with each other than they actually are. The problem is, I don't see necessarily the efficiencies that Stephen sees in moving forward in allowing technology to change the fundamental values of the justice system. Technological advances, in my mind, and the way that I've used them in the past 10 years and bringing iPads into the courtroom and electronic documents, is that it furthered our ability to pursue justice. It didn't undermine it. And so it became a tool that was used in the justice system. It wasn't intended in any way to sort of replace that system. The courtroom, in my mind, Gary, has always been the ultimate equalizer. And I believe that oral advocacy is our crown jewel. When an advocate appears in a courtroom to make oral argument, she's gowned like all other advocates. Means nothing whether she comes from a national law firm or a sole practitioner working from a small town. Doesn't matter if the back of the motion record says Gowlings or BLG or whomever, or if it just says ABC law firm in a small town. Everyone is the same as an advocate when you're standing before the court. The oral argument that is presented to the judge supplements what has been reduced in writing. And that's really where Stephen's argument is, well, everything's in the factum. Yes, it is. But a good oral advocate can bring that factum to life and can breathe life into an argument, which frankly, the decision maker may not have caught. It ensures that you're given the opportunity to really look the decision maker in the eye, develop your argument. It gives you and your client that reassurance that win or lose, you have been heard. And that's important because that's what our justice system is about. It's about making sure that people are heard and that they have their day in court. How many times as an advocate have you walked out of a courtroom feeling that was a really good hearing? Whether I win or lose that hearing, justice has been seen to be done. And I know we've all had that feeling, and it's a good feeling because it means you know the argument you presented has been understood, has been grappled with, and is going to be analyzed. Are we ready to lose all of that, Gary, for the sake of what I would term false efficiencies? Some things are worth waiting for. Those moments in the courtroom, whether on motions or appeals or trials, where you have that opportunity to look the decision maker in the eye and communicate with them and ensure that they understand and consider your argument. That's worth waiting for. I also want to talk for a second, though, about efficiencies, because definitely the backlog that we are experiencing in the civil justice system is a reason why some jurisdictions are looking for efficiencies. And one of the arguments, and I believe Stephen's put this argument forward as well, is that motions in writing, as an example, are more efficient. Why do we need to have a hearing? Why do we need to waste 2 hours of a judge's time with oral argument? Let's just put it all in writing and put it in front of them. But at the civil working group, I posed a rhetorical question to the judges that were assembled there. I said, well, how often does the court get a motions list of 10 to 15 motions on the night before motions court, only to find out the very next day by 10 a.m. that 70% of those motions have settled and only a fraction of them are actually proceeding? That happens all the time. And what does that tell you? It tells you that the oral hearing itself has meaning. It tells you that parties are reluctant to put themselves before the court with an argument that they maybe believe is a loser, know is a loser, or are simply embarrassed to appear before the court with an argument that they know will not be shared by the decision maker. So yes, some might say, well, that's a waste of time. Judges are forced to review these motion records, and then they're never argued the next day. But look at the other side of the coin. Those same judges do not have to write decisions on 10 to 15 written motions. They only have to write decisions on the 3 or 4 which actually proceed in front of them orally. And so query, how many of those 10 to 15 motions would have actually settled if the party knew that they never had to get on their feet to justify the positions they're taking in writing? I suspect quite a number of them, because the work in the written material has already been done. That's why it's on the motions list. It's been perfected. So that's why I say you have to be cautious in believing in false efficiencies, because it's easy to say this is a much more efficient system. Do a motion in writing, avoid the oral hearing. But that doesn't tell you the full story. This is a similar discussion, Gary, that I had once with RSJ McLeod in Ottawa at the peak of case management. He may have been a judge at the time of the Superior Court, or he might still have been a master, I'm not sure. But the thought was that we should case manage all upcoming trials 3 months ahead of time to see if evidentiary rulings or voir dires could be made in advance of trial to avoid the problem of trials that overrun their allotted time. Again, while this in theory makes a lot of sense, and most reasonable people would say that makes sense, we should do that and create efficiencies in the system. The problem is, we know that 90% of those cases are going to settle by the time you get to the courtroom door. So similar to the motions list, imagine 90% of those evidentiary issues and 90% of those voir dires are never actually going to be adjudicated because the case settles. Now imagine if you had to adjudicate all of those cases 3 months ahead of trial. The workload and the cost of the system would be huge. Another example of how efficiencies sometimes look really good on paper, but they don't play out in practice. I'll take a moment as well to talk about the trial itself. And this idea that was floated that the default system should be applications as opposed to trials. Again, this goes back to the argument that we should be able to resolve all of our disputes in writing. And only the exceptional cases should require an oral hearing or even a trial. In my view, the trial is and should remain the default for resolution of all legal disputes. It's not to say that motions for summary judgment or applications don't play a role in our judicial system. They certainly do. The party can convince a court that a trial is unnecessary, and the parties may avoid the cost and expense of a trial. However, the default should always be that disputes are resolved in the courtroom with viva voce evidence. Which brings me to the big elephant in the room, which is cross-examination. And I know during this conference, you're talking about cross-examination in the virtual world. And right now, we don't have any choices. We have to live with the pandemic and we have to move forward. And so a virtual trial, virtual cross-examinations are necessary because we don't have the ability to get together because of the pandemic. But let's not lose sight of the power of the cross-examination. The power of that cross-examination is at its greatest when there's nothing standing between the examiner, the witness, and a judge who's watching the show. That's an important piece of our justice system. And I frankly go out on a limb and say that's really what our system is built on. The cross-examination ultimately is the tool to getting at the truth, and people being put under pressure in a courtroom having to answer questions. You can't replace that. So whether you're going to do this virtually or not, and because you have to during a pandemic, it shouldn't become the rule, because to do that means you're allowing the technology to take over the justice system as opposed to allowing the technology to be a tool of the justice system. So Gary, I don't know if I've answered all of the points you wanted to talk about, but you did ask us to look at what is civil litigation going to look like in 2030. And my answer to that, and at least I hope this is how it's going to play out, I certainly hope it won't be the vision that Steve has, because that's a scary vision. But it will be a different vision. And what it will be is it will look like what we have today or before the pandemic, but with technology as our biggest tool, which means we will have electronic productions, we will have electronic discoveries, we will have electronic exhibits. But at the end of the day, when the dispute needs to be resolved between two parties looking for justice, those two parties are going to end up in a courtroom, in person, with a judge. And we are going to hear real evidence from people that are going to be sitting before the judge and that are going to have to be cross-examined on their opinions or their version of the truth. And so I see technology as moving us forward. Without a doubt, we're not going back. I don't think we're ever going to go back to paper documents or paper exhibits or paper factums or paper authorities. That train has certainly left the station. But I don't think we're going to lose what our justice system is built on, which is the power of the courtroom and the viva voce ability to communicate both with the decision maker, our opposing counsels, and ultimately the witnesses.
Well, thank you, Joseph. Stephen, I want to give you an opportunity to respond to remarks, and perhaps you can focus on Joseph's concern about the lesser role for oral advocacy throughout the civil litigation process.
Yeah, thanks, Gary. Well, I think we need to remember that the system doesn't exist for the benefit of lawyers or judges, and it is there for the citizens of the province. And in my view, the system that Joseph hopes to return to has not functioned well throughout my entire career, and is actually in many ways functioning much better now. I don't hope to return to the old system, although I expect it will be some sort of a hybrid of the current system and the old system. But to take as an example Joseph's comment about the importance of cross-examination, I don't disagree with that. But many judges have told me that they actually find that conducting or hearing cross-examinations conducted by video conference is a better tool for them, because it gives them an opportunity to see the face of the witness up close rather than craning their neck to look sideways at them in a witness box. Usually they can hear them better as well. They can see the documents and look at the witness at the same time. So I think Joseph was drawing a distinction between written advocacy and trials. I'm not suggesting that written advocacy is suitable for all types of disputes. Certainly personal injury cases that Joseph would usually be involved with less obviously lend themselves to being dealt with in writing. But I don't see, apart from jury trials, which are a separate a discrete problem, I don't see any reason that they can't be done quite effectively and are being done. Joseph's doing them himself in video, by way of video conference. So the advantage of commencing a proceeding by application, in my view, and this was certainly the rationale articulated by Justice Beaudoin, is that it forces the initiating party, the plaintiff or the applicant, to focus on what their case is about at the front end, instead of winding through the wilderness of litigation for years before finally the real substance of the case is brought forth. All that work is at the front end, and then the dispute can be dealt with, not necessarily all in writing, but perhaps part of it can be dealt with in writing, and other parts can be dealt with by way of an oral hearing. But what to me is exciting about the new way of litigating that we have been dealing with since the pandemic started is that there are, as Joseph said, efficiencies of all sorts that don't require travel, even travel within the city to go down to the courthouse and wait around for an hour before your case is called. Instead, you get in front of the judge, the case is dealt with, and you're on to something else. The client is not having to pay for travel time, waiting time, and so forth. So to me, things have gotten much more efficient. And in my view, we are not going back to anything like the old system. It's going to go far beyond just electronic documents. And that's something that I am enthusiastic about.
Well, thank you very much. And thanks to both of you for the debate on this very interesting topic that will be with us for at least the next decade to come. If anyone in our audience has a question for